had an issue yesterday where they started giving comments and they didn't have the score written down, so I had to come back and your notes, enter the rule book says can't do that, turns out.
If you don't mind, do you want to give an introduction of yourselves or a background, you know, the knowledge you guys have?
Sure.
As it relates to the
Yeah. Oh, no, that's fine. I guess my name is Keen Zimmerman. I'm currently at 2L here at Michigan State University College of Law. I did mock trial in my undergrad. I'm trying government court codes now, so I'm intimately familiar. I spent summer doing, I spent summer in Chicago with the Department of Buildings and their Drug and Gang House Enforcement Division doing hearings with owners of brothels and drug houses, crack houses. So to the attorneys, controlling your witness, depending on what they are and what they do, can be very difficult. So I understand that.
My name is Tia Duso. I just passed the bar in Michigan.
Congratulations.
So I'm just looking for a job. My experience is mostly in prosecutors' offices, so I'm pretty familiar with criminal. I was glad that this was a criminal trial because it's a lot more familiar to me.
My name is Joe Duso. I graduated from law school and I'm currently studying for the bar exam, which will take in February. I had a mock trial class, law school, and competed in a couple competitions. Didn't have any internships, externship experience in trial settings. I focused more on other areas. Oh yeah, that's irrelevant. I went to law school part-time and worked throughout it, so, but anyway, I think we have everything back here. The score's turned in?
Yes.
Yes, thank
All
you.
right.
Well, okay, so I have notes in front of me, so I'm gonna go first before I forget everything, and these guys can look at their stuff. But first of all, I'm always really impressed with you guys and how prepared you are and how much you know. I mean, rules of evidence are not easy, and law students don't understand them. Some lawyers and judges don't even understand them. So I was really impressed with some of the arguments that you guys gave today when you were dealing with objections and the rules of evidence and things like that. You came up with good arguments, and you had rules to back them up. You weren't just like making stuff up. I know you guys made a lot of objections, and I know I overruled a lot of them, but that doesn't mean I didn't think they were good objections. I think you really made them work for what they wanted to do. So that's always good, because otherwise, if you're letting your opposing counsel just do whatever they want, then that can derail you really quickly. But I think you guys, for the most part, did a good job at kind of bringing everything together in your closings. As far as any individual things, I think maybe for you guys, a couple of your crosses seemed a little long, and maybe there were things in them that I didn't think were really that important. And I think a good cross, and this is just general advice for everyone, a good cross is usually picking out a few points that you really want to hit hard, and you don't want to let the witness reiterate anything that they've already said on direct. You don't want to let them paint the picture again because they've already done that once. You don't want the jury to hear that again. So I think really figuring out what exactly it is that you want to trip that witness up on, and hammering that, and then sort of backing off. And I know you kind of open the can of worms with that conversation in the limos, and a real judges will do that. If one side, particularly if the prosecution opens a door, they're not going to shut it on the defense. So just you have to kind of pick your poison and know that you're getting into that if that's what you want to do. So, but I mean, I think you guys all had good presence. I wasn't bored by any of you or confused by any of you. So I always think that's good. And witnesses, I like to. These witnesses had a little more personality than I did around yesterday, and I think as witnesses, you had a little more personality to you, so that was kind of fun. You probably have more helpful advice to give them.
Actually, I was going to say, because I know how much you treat these comments like religion. I've been in that car ride back. I know what you're gonna end up going over at, like the big warrior Sonic. So again, if you want specific comments, I'll say afterward. And if you want like individual feedback, in terms of general comments, I think everyone did a really great job. I was an expert witness a lot, so I understand the struggle for witnesses. It's there. You have to know the law and the rules of evidence as well as the attorneys do. And then attorneys, the best thing I can say is if you have a witness that they're getting 5, 6 yeses in a row, don't leave them out there. Like, give a relevance, something, give like 401, 403, just something just to break it up because you don't want to leave them hanging 3 sheets to the wind. In terms of general comments, I know it's the 4th round, I get it, everyone's tired, don't fall asleep in the back. I feel you, I know, I understand. Chewing gum, it just depends on the judge. I could care less, but depending on who you run into, that could bother someone. I mean, generally, I think everyone did a really good job. The evidentiary objections were really good. I think the attorneys were able to read the judge well enough to know when they should stop arguing, when they should keep arguing. Sometimes yes, sometimes no, but I mean, I think everyone made substantive objections. If anything, I know you guys have only had this for a little while, so the fact that a lot of you weren't using notes is really impressive. For certain things though, the less you can use them, the better it's going to look. But again, I think everyone did a great job. Knowing that as soon as I say everyone did a great job, no one wants to hear that because it doesn't mean anything. But I really do think you did.
That is, I mean, just the notes thing always gets me too, because in real trial, like everybody uses notes. Like nobody goes, you know, for the most part, because you just don't have the time to, you know, you guys put in infinitely more time into doing this than an actual attorney would have to put into each individual case. So I mean, you know, for somebody like me who's used to always having a notepad in front of me, I'm like, you guys get up and do, you know, a 10-minute examination with nothing in front of you. I'm like, all right, I wish I could do that. It'd be nice. So I mean, props to you guys for being able to remember all this stuff.
Yeah, this was the second round I've done as well, and last night it amazed me at your understanding and grasp of the rules of evidence. And then again, you did well. You guys had several objections, and like Ted had mentioned, you made them work. They were overruled a lot, but they weren't improper objections either. On that note, when you're objecting, you can see both sides, the 2 counselors, chomping at the bit to make a response. Don't interrupt until the other side's done. Atea, she's more laid back, but you're going to get judges that are not going to appreciate you jumping in.
Well, mostly for the record. Everything in a real court case, everything's being, you know, word for word typed down, and if you're talking over each other, the judge has to stop you because they can't make a record that way.
So there's that. Just wait until once they're really done, you've heard the couple-second pause. You can either ask to respond or just begin your response. Just know your judge. The other thing is when you're talking, make sure you're making those comments to the judge and not towards the opposing counsel. There were a couple times you guys would look at the opposing counsel as if you were making them towards them. Like I said, depending on the judge, sometimes they can get a little testy about that. They want the comments to them. It's also just a sign of respect as well. The other thing with the record, with the wristbands in particular, there was a couple times when you would reference them or the witness would reference them, they'd say this wristband, and that's great right now because we can see the wristband. What the lady that I was with yesterday, she had mentioned, and sometimes you forget about it, maintaining the record on appeal. They're not going to know what wristband you're talking to. So they're all different colors. I think one might send this nicely colored wristband. Follow up with what color is that wristband. There's that. Overall, like I said, it was all well. If you guys want individual feedback, I'll sit here for a few minutes afterwards and I can tell you what I thought about each individual performance. And you can scrutinize my notes if you can read my handwriting.
Do you guys have any questions?
Where are you guys from?
Northwood?
Northwood?
We're from Hillsdale College.
Hillsdale? Oh, cool.
Individual comments?
Yeah, if you have one, a couple comments, go ahead.
Yeah, very nice.
I don't remember any.
Good job.
Thank you so much for doing that.
That was
launch, I've seen a lot of launch.
You know, you talked about
Were you guys, yeah, were you officially going to be the expert? Yeah, I got in the it's so much more fun. Yeah, the other one like half. He actually they got pretty on sort of like my last round. I know you were working really well. You were going hard.
Good job, Tom. I try, man. I try to be all-American.
I stopped the opera keeping last year.
That's a good dish, yes.
Don't do that. When they had
That's true.
Well, I don't think I can just like take it down. I'm like, I'm trying not to take it. like slipping the screen off this. I was gonna say, you guys said my new year, you gotta have a break and start again. Yeah, exactly.
It's 5 to 6. There's another security guard. He's got cameras everywhere.